15. Appellate. Anytime you're ready.
Good afternoon, Your Honors. My name is James Fishman. I represent the appellants in this case. Your Honors, this case involves the sale of a book with an associated updating
Let me
service.
stop you there. Sale of a book. UCC applies?
Yes, it does, Judge. And we've cited cases that show that the book, well, Judge Ramos said that the updating was incidental. It wasn't incidental. It's the reason for buying this book every year.
So UCC applies. Did you
UCC
notify?
Does not apply.
Did you notify? It does not apply.
We're arguing that it does not apply, but even if it did apply, notice was given. That's our position. But this book has the year on the front of every book. They sell this book every year with a different year on it.
They sell it. Is there an agreement pursuant to that sale?
There is
Anything?
an agreement that is on the reverse side of the invoice that's obtained after you buy the book.
I didn't ask you where it was. I just asked you whether there was one,
There
right?
is one, yes.
And what does it say?
Well, it says that you're buying a subscription service. That's what they're offering. They use that term.
Didn't also say that there's no warranty of the accuracy of the book?
Yes, and that disclaimer is a nullity, Judge. The cases say that you cannot disclaim the essential purpose of the product. It's like Chevrolet saying, you can't use this car for transportation. This book was written for people to use for the content of the laws affecting.
But it's a little different than Ford saying you can't use it for transportation,
They're saying the
right?
book isn't
They can say
accurate.
you cannot use this car to do road racing, right?
Well,
So in this case, I mean, what Lexus is doing is probably saying, you know, we miscite a book or we include the wrong citation.
no, but it's a lot more than that, Judge.
it's more than
We
that.
have
Tell me why.
37 instances that we found just in the sections dealing with the rent regulation law. Each one of these tabs is either an omission or a false statement, where they actually published a law that had been repealed. And they're saying it's current, and that it had been repealed 11 years earlier.
But
That
he
is
says,
a false-
they don't warrant accuracy, right? Reliability or currentness
Right.
of the materials contained in the
Again,
public.
and the cases say you cannot disclaim the essential purpose of the
So that's
product.
a public policy argument.
I think that's what the cases say, whether it's public policy or not. Why would anybody buy this book except with the assumption that it's current? In fact, they have a section in every year up until the 17 year where they say table of
Maybe they buy
legislative
the book
amendments.
because, maybe they buy the book because it does give guidance and give information, but.
Well, that's a
but-
small.
But when it comes to actually relying on something that's in it, maybe you better go to check McKinney's or the regulations or the rules before you
This is a
actually sign it.
1,500-page book. If everybody who bought it had to sit down and do a line-by-line comparison of everything in here with the official, by the time you finished, you'd be ready to buy another book. It would take a year to go through this book and do a
But they're all the
line-by-line
sources,
analysis.
they're all the sources that you can corroborate that information with.
I'm sorry, Judge?
If they say a particular case stands for a particular proposition,
That's not what we're saying, Judge. We're saying is they took the words of a statute that were enacted by a legislative body who were elected to write such laws, and they lied about what those laws said.
Wait, but there's nowhere in the book that it says, this is a complete presentation of all of the laws and regulations.
Well,
Is
if you
there?
look at
I mean, what you refer to as creating an express warranty doesn't say, this is everything there is.
well, I think you have to look at how they describe these laws right on page 1. They say selections from federal laws, select local laws, and then the rent stabilization and rent control laws and regulations. They don't say select, they don't say excerpts, they say
They also don't
the
say
laws.
all. They also don't say all.
They say rent stabilization and rent control laws and regulations. And in other parts of the book, they say the rent stabilization law, and that's what they say in their advertising. They say it throughout the book. And that's why, I mean, why would you buy a book that has, 75% of the rent stabilization code, and you don't even know which 25% is missing? That's the whole point of buying the book, because you can have that entire law in one place. You can take this to court. You can have it on your desk when you advise a client. Judges are using this book. The OCA buys this book. They used to, but not anymore. But that's the whole point of the book.
The book is not good enough doesn't necessarily give rise to a cause of action.
I'm sorry, Judge?
Even if the book is not a great book, that doesn't necessarily give you a cause of action.
I don't think this is a subjective analysis, Judge. This is an objective defect. These are laws that were enacted that never made it to the book for 11 years. I mean, they had the income limits for scree and dree at $16,500, which is where it was in 2005. It's $50,000. It's been raised 3 times by the city council. Somebody looking at this book could advise a client, say, I'm sorry, your $20,000 income, you're not eligible, and rely on the book. Or a judge could do the same thing. How is it that Lexis, which owns Bender, and is the largest data legal publisher in the world, can't keep up with what the city council does with the rent stabilization law? That just boggles my mind that you can't rely on this to be what it says it is. And that's the problem. They say it's X, it's really Y. And that is
The fact that it boggles your mind doesn't necessarily create a cause of action.
Well,
That's the problem I'm having with it.
it's like offering to sell it's bait and switch, Judge, and that's a cause of action. It's deceptive. It's deceptive to
Except
say.
they tell you we're not warranting its accuracy.
Well, all right. The other problem, Judge, with the disclaimer. The warranty disclaimer can't be on a document you get after you buy the book. Why isn't that warranty on page 1? They have a disclaimer on page 2 of the book that says, don't rely on this book it says, if legal advice or other expert assistance is required, the services of a competent professional should be sought. Why aren't they saying it there? They're giving that warning to lay people. Don't use this book without talking to a lawyer. But why are they burying it on the back of a invoice that's sent to the people who write the checks to pay for the book, not the people who are using the book? Every law firm that buys this book, they don't see that document because they're not writing the check to pay for the book, so they don't see the invoice and this fine print that's on the back of that invoice.
But whoever is writing the check gets to see the invoice before writing the check.
Yes, the office manager of a law firm, for example, gets to see that. That's not the intended user of the book. The intended user of the book, if they want the intended...
Wouldn't the agent's knowledge of the warranty presumably be imputed to the principal, the law firm, under these circumstances?
If that were the case, Judge, everything that passed through an office manager's desk would then be imputed to the lawyers on business matters. Judge, I think that's a can of
The flip
worms.
side of the coin is the warranty will never have, a disclaimer of warranty will never have meaning if that's your argument, because, well, it went to some lower-level employee, and we're not bound by...
But if you want that disclaimer to be seen, then put it where it will be seen by the user. It's the user that needs to see it, not the person who pays for it. And the other problem with it is it goes to the action, as I said before, it goes to the purpose of the book, and you cannot disclaim the essential sine qua non.
So, but what's that
Why
based
you
on?
buy this book.
Isn't that argument based on the UCC, based on Section 2719 of the UCC?
Yes?
But
That-
on one
and
hand, you argue...
313 says you can't disclaim something that is the essence of the bargain.
So on one hand, you argue UCC doesn't apply, but in this instance,
Well,
UCC does apply.
Obviously, we're taking the position that we don't believe it applies, but if you find it does, then 313 says it's the essence of the bargain, and you can't disclaim it. It's what the book is purchased for. And if you look at the specific language of that section of the invoice, they also say the only thing they're really disclaiming here is that the book is free from defects, meaning if the pages fall out, that's what they're disclaiming. They're saying it's
About
free from
accuracy.
defects.
We don't warrant the accuracy,
Right.
reliability,
Right.
or currentness of the materials contained in the publication.
Again, Judge, if it's not a current book, why put the year on it? You could buy one book and never buy another one if you believe that one book would get you through the next 5 years. They make money selling this book every year because,
The legislature changes laws.
right, all the time.
All the time.
Right.
And so in a given year,
Right.
After publication, a law could change that would make the
Well,
publisher.
I mean, during the year.
Right.
Yes, and that's why they have,
So my point is that someone looking at the book at the end of the year, perhaps, after a change has.
Better check that pocket
would-
part.
Yeah.
but they don't do pocket parts for this book. Every year, they had a
Not in that book, but they
table
do
of amendments.
in the books that you
in the
should be
front of the
looking at.
book, so you could see all the amendments that they did catch. However,
Yeah.
that's about 5% of the actual amendments that occurred.
Thank you, Mr. Fishman.
That year. Thank you.
Good afternoon, Your Honors, and may it please the Court. Anthony Dreyer on behalf of Matthew Bender and
So
Company.
why doesn't the public policy argument that Mr. Fishman raises dispositive in this case? I mean, the town book is pretty much the Bible in landlord-tenant law, right?
Well, respectfully, Your Honor, what plaintiffs have to show is more than that there was an error in the book. We concede for purposes of this motion that section was not complete. They have to cite to more than public policy. What they have to do, the essence of this motion is, have they met the pleading requirements that this court and the Court of Appeals has established for their causes of action?
But
As
wouldn't
Judge-
you agree that you've held this out as being authoritative in the area of landlord-tenant law?
Well, they point
Certainly
to...
in your advertising material, you hold it out as authoritative, don't you?
The word authoritative is used, but respectfully, Your Honor,
One would
what
assume
they're...
that authoritative would mean that it was up to date and complete, right?
Well, respectfully, Your Honor, they have an express warranty claim, and they have fraud claims and 349 claims. Every single one of those claims requires as an element that the plaintiffs saw the alleged misrepresentation, and none of them have alleged that. They've had 2 complaints, they've each put in sworn affidavits, and none of them...
The law firm, wasn't there an affidavit from Himmelstein discussing reliance in this case?
What the plaintiffs carefully said in their affidavit was, we understood, we assumed it was complete. Not a single one of them said in their affidavits, under penalty of perjury, that they went to the website and saw certain language. Not a single one of them said, we looked at the inside cover. Not a single one of them said that we looked at the word "the" in the supposed express warranty. That's not in our contract, it's in the book. That is fatal to every single one of their claims. The other problem that they have, as the court has pointed out, is the express warranty. Now, that agreement, by the way, and it's clear on the record, was not given after the fact. The subscription terms of service they entered into were in 2011, and we didn't just randomly pick somebody to send them to. We sent them to the person, they said, this is who we want to handle our subscription.
How do you respond to the argument that the warranty is invalid because this goes to the heart of the bargain? What's your response to that?
Well, I don't see how it could go to the heart of the bargain, and
The
the
heart of the
argument...
bargain is they want a complete and authoritative list of laws.
Well, as Justice Ramos found below, it's impossible for it to be the heart of the bargain for 2 reasons. Nobody ever said that they saw the supposed representation in the book, and 2, we know from the record it's not the heart of the bargain, because
Counsel, people buy this book so that they can counsel their clients, so that judges can make decisions, so that attorneys can file complaints, so that advocates can advocate for their people. You know why people buy this book. So on the law, may you be correct, perhaps, but let's not, there's this big elephant in the room, like there's nothing wrong with the fact that you're publishing a book that is not accurate, not complete, and has strife with errors. That's a problem.
Justice Manzanet, I agree. This is not something that people at Matthew Bender were happy about, believe me. And they took steps to make sure.
You say that.
No, absolutely, and forgive me for suggesting otherwise. But nevertheless, that doesn't divorce us from the fact that they have to show elements of their causes of action. Take damages, for example. They've not identified any incorrect advice that they gave in the 17 months that they had the TAN book. They've not identified any incorrect court pleadings. The only one they cite to is not a plaintiff. It's somebody who has nothing to do with this case. On top of that, Your Honor, again,
Well, that person you say has nothing to do with this case is a putative class member.
he's a
I
putative...
don't understand why that's not a relevant person.
Well, respectfully, and this isn't in the record, he's not a putative class member because Matthew Bender dealt with him separately, but for
But that-
purposes of
That
this...
doesn't define, as the class is defined, it seems to me he would be a putative class member.
He may be a putative class member, but obviously no class has been certified,
Well,
Justice
I understand
Gesner.
that, but he doesn't have nothing to do with this case.
Fair enough, but the only individuals and entities that we can look at for purposes of this complaint are the named plaintiffs. And none of those plaintiffs, despite having, again, multiple pleadings, have identified any injury that they've suffered. The only injury they cite is to say, well, if we knew this section was not complete, we would not have purchased the TAN book. The problem with that argument is the Court of Appeals has said in the Lorillard case, that's not sufficient injury for a 349 claim. You can't say I wouldn't have purchased the book, but for the deception. And in a case that's extremely analogous, the Reichs case, the second department, in a case where there was a purported misrepresentation about who the author of a book was, the plaintiff said, we never would have bought the book if we knew there was a co-author. The second department, citing the Lorillard case, said that deception as injury is not enough. You need to plead a
That's
separate
much more-
injury.
I mean, not knowing who the author is seems to be very different from saying, as you do in the record of 211, citing the book itself, this publication is designed to provide authoritative information, and what that means is some of the laws. As a judge, I wouldn't consider some of the laws authoritative.
Well-
And I would have thought that your client wouldn't view some of the laws as authoritative. I'm sort of disappointed to learn this.
Look, I think in some respects it's a form of puffery, but it is impossible, even in a
I'm sorry,
15...
authoritative is not puffery.
Well, in a 1,500-page compilation where you're covering not just rent stabilization, but all of the other topics, it is impossible to cover all the laws, and that's why we disclaim completeness. And quite frankly, to Justice Manzanette's point before, it would be impossible. Even if the TAN book was 100% accurate and complete on January or December when it was published, the law is fluid, the law changes.
Like I said, yes.
Exactly. And unfortunately, people make mistakes. If every publisher of these types of textbooks were held to a 100% completeness standard, nobody would make these textbooks. And that's not what happened here, Your Honor. Let me just make one other point on the fraud issue. For all of the same reasons, the fraud claim was properly dismissed by Justice Ramos. The plaintiffs have to allege that not only were there false statements in the TAN book or in the marketing, but that when Matthew Bender made those statements, they knew they were false. There's no facts to support that. The only facts in the record are that in late December of 2016, it had recently been brought to Matthew Bender's attention. For that reason, Justice Ramos properly dismissed the fraud claim. But there are other reasons. Most importantly,
They
again...
rely on the failure to update. It took you 5 months to update the book once they pointed out the inaccuracies and incompleteness of the book.
Well, obviously, Matthew Bender wanted to take his time and get it right, but there's no obligation to update. The only thing they point to, and they only raise this on appeal, it's not in their complaint, it wasn't presented below, is they cite the language about getting pocket parts and updates. And what that language says is there's no obligation to update, but if we do during a subscription year, of course, we will send you the update. But there's no obligation to update, and there's certainly no statements that we made in the interim that they can point to that they relied upon to their detriment. That's the essence of a fraud claim. It's the essential element, and they don't plead it. Unless there are any other further questions, we'll rely on our papers.
Okay, thank you.
A few points I'd like to make, Judge. The last one about no obligation. What about when you know, you have actual knowledge, and we have the Mars email to Mr. Cheshire in December of,
How fast are they supposed to do that?
I'm sorry?
How fast are they supposed to do that?
They should send an email or a letter to all their known customers, because they know all their customers, because they sell to them by mail and online. They know who all their customers are. Send them a letter. We just discovered the book has problems. Don't rely on it. We're going to
There's nothing
update.
in the material terms that would should lead you to expect that.
Well,
Material
I'm
terms say that.
talking about good
if they-
faith here
if
and
they
fair
write-
dealing.
If they write any updates, they'll send it to you.
But that's different. That's if the law changes, not if the law was never reported properly or we misstated what the law is. That's for updates. Updates are changes in the law, not things we never put in the first place. Or
What are the
things that-
damages for failing to do that?
It's the cost of the book, Judge. And that's exactly what their terms and conditions say. They limit their damages to the purchase price of the book. It's right there in the contract. So they've already conceded, if you have any claim relating to this book, your damages are the price of the book. And that's all we're seeking. We're not seeking any more than that.
Your client bought the 2017 version of the book after knowing all of this.
Well, because they
Doesn't that
fixed it.
undercut its claim for damages for that year?
This is the 17 book, Judge. There are no tabs here. Every one of those tabs has been fixed. We now have an accurate book, thanks to the plaintiffs in this case. So, sure, we're going to buy it.
Your
Now we
complaint
know.
is though that they charge you full price and they only released
Right.
it in May of
It
2017.
did. This book was always came out in January. You had a full year's use. They released this one in May, and then the following January, they said, okay, now buy the 18 book. So you had the 17 book at full price, which they never told you, by the way, during that period, don't use the 16 book. They never said anything on their advertising, don't buy the 16 book. They didn't even take it down from their website. They didn't take it down from the Amazon website when they knew the book was defective and shouldn't be relied on.
Thank you, Mr. Fishman. Thank you both.